next case to come before the court is State of Ohio versus Clarence Fry, and we're going to have the same parties because we're going to have two different appeals relating to Mr. Fry this morning. Each of you will have 15 minutes to present your, oh, I'm so sorry, I forgot to go. This has been the morning we've been having. You didn't miss anything, I'm just explaining to you.
I understand. I've heard it before.
Each of you will have 15 minutes to, and I apologize for the delay. We had some conflicts that arose unexpectedly, so that's why we're a little delayed, and that's why I'm just proceeding along without even having the third judge here. Anyway, so each of you will have 15 minutes to present your argument, and obviously the appellant may reserve up to 5 minutes for rebuttal if you so choose. Please do not use the name of victims, do not use the name of children, because everything is kept on line in perpetuity. So if you want to reserve some time, just let me know what that is, and like I said, it can be up to 5 minutes. And we are ready to listen. We've read the briefs and prepared.
Thank you.
Thank you. And just stay there behind the lectern because we're recording.
No problem. Good morning. May it please the court. My name is Jacob Seidel. I represent Clarence Fry. I would like to reserve 5 minutes for rebuttal, please.
Thank you. And by the way, you see the monitor over there too.
Thank you. The sole inquiry in this case is whether Clarence Fry, utilizing reasonable diligence, could have discovered evidence that existed only within the mind of a juror within 120 days from the date he was sentenced to death. The answer is no, he could not. And the facts of the case evidence this. These facts include Fry's post-verdict incarceration, the date of the termination of trial counsel's representation and the scope of their representation, the date of the appointment and scope of direct appeal counsel, the fact that the trial record and transcript were not filed until after 120 days following verdict, and the fact that no evidence was present during the 120-day period following the verdict that would have prompted Fry or counsel to immediately inquire of jurors whether they understood the jury instructions to preclude a vote other than that of death. This evidence established at the very least a prima facie showing that Fry was unavoidably prevented from discovering the evidence within 120 days of the verdict. Where a prima facie case of unavoidable prevention is established, leave must be granted, or at the very least, the trial court must hold a hearing to determine whether there is clear and convincing evidence of unavoidable prevention.
So from the time that counsel was appointed for post-conviction relief to the time now, or to the 120 days, excuse me, how long was that?
Your Honor, I don't have the exact amount of time that post-conviction counsel was appointed, but what I can tell you is that post-conviction counsel was equally dependent on the filing of the transcript and the record to begin any comprehensive investigation of the case, which could ostensibly include jury interviews.
I guess I'd like to nail down the timeline of when he had an attorney and when something would actually have been due.
Your Honor, I can tell you that direct appeal counsel was appointed a few weeks after the verdict in this case. They would have been appointed July 28th is when his direct appeal counsel was fully appointed. However, notably, direct appeal counsel's representation is limited to reviewing, obviously, facts from inside the record, and they were equally dependent on the filing of the record and filing of the transcript. The filing of the transcript and record happened, in this case, 156 days after the jury verdict, in this case, sentencing Fry to death, and 129 days after the judge adopted that verdict and sentenced Fry to death. So both post-conviction counsel and direct appeal counsel would not have had the record of the transcript within the 120 days following the verdict to begin any comprehensive inquiry of jurors, or even to begin investigating the record, to investigate jury questionnaires, to investigate any notes that were passed to the judge, so that they could begin an inquiry into whether jury interviews were necessary. The trial court abused its discretion when it denied Fry's motion for relief without holding a hearing. The process for filing a new trial motion based on newly discovered evidence more than 120, that's filed more than 120 days after the verdict triggers a bifurcated judicial process. First, the petitioner must be granted leave. In considering a motion for leave, the court does not look at the underlying merits of the new trial motion. The sole inquiry is whether the petitioner has submitted clear and convincing evidence that they were unavoidably prevented from discovering this evidence within 120 days. And moreover, as articulated by the Supreme Court of Ohio, State v. Bethel, Criminal Rule 33 does not impose a reasonable time filing requirement on a petitioner.
So how can you get around that this is 16 years later?
Your Honor, because Criminal Rule 33, and like I said, the Supreme Court articulated this in State v. Bethel, has established that the rule only looks at whether the petitioner was unavoidably prevented from obtaining this evidence, discovering this evidence within 120 days of the verdict of trial. For purposes of leave, that is the sole time period that the court looks at. If they were unavoidably prevented, if it was established by clear and convincing evidence, then leave should be granted. If a petitioner has established a prima facie case of unavoidable prevention, but there are discrepancies, those discrepancies should be resolved at a hearing to establish that there was clear and convincing evidence of unavoidable delay. Here, the trial court, as I stated previously, adopted the jury verdict and sentenced Fry to death on July 11th, 2006. Thereafter, Fry was incarcerated. He was reliant upon his counsel to engage in any investigation on his behalf, especially an investigation of meritorious claims. His trial counsel's direct appeal counsel's representation, though, was limited to evidence inside the record. During this 120-day period, there was nothing to indicate to direct appeal counsel or his prior trial counsel that they needed to immediately investigate anything regarding the jurors. This juror did not say that she had confusion about the jury instructions or that she thought the jury instructions precluded death. Had there been evidence that prompted counsel, then maybe Fry and counsel could have discovered this evidence within 120 days, but there was nothing that would have prompted diligent counsel to begin this investigation.
And that makes me think of another question in regard to that. So you're not alleging that there was any problem with the court's jury instructions about him waiving the mitigation phase?
Your Honor, I believe that that issue would go to the underlying merits of the new trial motion and wouldn't affect the...
Well, it also goes to whether the attorney, the original attorney, the direct appeal attorney, was put on notice.
That is correct, Your Honor.
If the trial judge said, well, you know, since he's waiving, therefore you can just find him, you know, the death penalty is appropriate.
There was nothing within the jury instructions that would have prompted counsel to believe that this was an issue. Certainly, the jury would believe that she was instructed to weigh mitigation against any of the aggravating circumstances, and believed because mitigation was waived that therefore precluded a vote for life. But there was nothing from the jury instructions that would have prompted counsel to go and question this juror during that 120-day period.
We're talking about unavoidable prevention. What would stop counsel from going to the jury commissioner and finding out who was on the jury with names?
Your Honor, I believe that comes back to the reasonable diligence aspect of this. Counsel could have obtained the name of that juror. However, that does not mean that they had the necessary information to begin a comprehensive investigation of this case. It would have been premature to interview jurors during that 120-day period, only having the name of the juror. Again, they didn't have the benefit of reading the trial transcript. They didn't have the benefit of reviewing the record in this case to look at that juror's questionnaire or again, see any notes the jurors had passed to the judge. So at that point in time, during the 120-day period following the verdict, it would have been premature to engage in any juror interviews.
But that juror did speak with the media, correct?
That is correct, Your Honor. That juror did speak with the media, and I would agree that her name was a matter of public record at that point, at the point that she had spoken with the media. But the very fact that her name was ostensibly known, at least to Fry, and maybe to direct appeal counsel, does not immediately lead to the conclusion that they possess the necessary information to, again, begin those comprehensive interviews of jurors.
Well, wouldn't in due diligence all death penalty counsel want to, for post-conviction, want to talk to the jurors? Because there's case law that if the jurors considered sex or race would be a problem with the verdict. So wouldn't it just be due diligence to figure out who these jurors are?
Your Honor, I
And
would,
then talk to all of them?
I would very much,
About what they were talking about in the trial.
I would very much agree that post-conviction counsel has an obligation to engage in juror interviews. But direct appeal counsel only raises issues from within the record. So direct appeal counsel would not have the obligation to engage in jury interviews unless there was a specific issue that prompted that. Post-conviction
Right.
counsel,
And they were already on, you're saying all of those people were appointed 3 weeks after the verdict. That's my understanding.
direct appeal counsel was appointed after 3 weeks after the verdict. I do not have the specific date of post-conviction counsel in front of me.
Okay.
I would be happy to provide the court with that date after additional investigation. But I would.
Counsel, that leads me to another question as well. You know, it seems like in some respects you're arguing for changes to be made to the criminal rules on the basis of whether it's policy or due process, whatever it may be. Like, for instance, what you were just talking about, since the direct appeal attorney only looks at what's in the record, and this is a death penalty case, seems to me what you're arguing is that there should be either the time extended in all these cases, and/or that post-conviction relief attorney should be appointed initially if the time isn't extended, so that he or she can get to work on the other aspects of what's not in the record.
Your Honor, that is not the argument that I'm making. The rule includes an element that counsel is reasonably diligent in their discovery of this evidence. I believe the facts of this case establish that reasonably diligent counsel could not discover this evidence within 120 days of the verdict, specifically related to the facts of this case alone. Placing the burden on a petitioner to immediately inquire of jurors without all of the necessary information poses a danger to the juror's peace of mind. Moreover, it can be dangerous to a defendant who could face accusations of retaliation or intimidation by jurors who feel harassed by the defendant's counsel, who didn't have adequate information from which to ask all of the relevant questions at an initial interview. This danger is continued onslaught of jury interviews because counsel who's in the position to conduct these interviews did not have the necessary information to begin.
And I'm asking you so many questions, I'll let you get into your rebuttal time. You have 3.5 minutes, you want to save that?
At this point, I will say that.
Okay,
Thank you.
You may proceed.
May it please the court, I am Rick Raley, appearing today on behalf of the appellee of the state of Ohio, and for the last time in my career, prosecutor Sherry Bevan Walsh. I'm here to ask that you affirm the trial court's denial of leave in this case. I'd like to start out by just talking, there's been some reference to the Bethel case from the Iowa Supreme Court. I believe that that is inapplicable in this matter. There was a obviation of the reasonable diligence requirement when there is a suppression of evidence in terms of a Brady claim. That is not at all what is at issue here. And the important policy issue that we are, principle that is before the court, is the idea of finality of judgments. And the fact that Rule 33, as it is written, is designed to protect defendants' abilities to challenge their convictions, but also that finality, which is why we have the 120-day period. And the defendants' arguments for their new trial is really advocated for an exception that's going to swallow that rule. There had to have been reasonable diligence used by counsel in this case by this defendant. This juror that they have brought to the court now was publicly known at the time, and this is 16 years later.
Well, just because somebody is publicly known, if you only have an attorney that is representing you on direct appeal, obviously with the record, because we say that all the time, we can't consider things that are not in the record. Why would that attorney know within 120 days, and especially since the record wasn't even filed for 136 days, that they had the obligation to interview jurors, even if they knew the name of a juror? I assume in the newspaper there wasn't anything that said, I didn't think he should be sentenced to the death penalty.
So I think that it's an obligation to lawyers to talk to jurors if they're able to after every trial. whether it's an F5 or F9 case. And it's something where that understanding of there may have been any issue with jurors, because we see these constantly in death penalty cases, that is something that you would want to pursue potentially.
So when you say counsel has an obligation, obviously there'll be different counsel for appeal.
Correct.
Those jurors are not accessible the way they were right after the trial. A usual trial is, they have the right, if they want to speak with you, fine. If they don't want to speak with you, they don't have to. But I guess my point is, by the time appellate counsel is appointed, it's going to be several days at least, if not weeks. And so then it's not as simple as just saying, may I talk to you jurors about your verdict?
Now, Judge, this may be a circumstance where if we had evidence in this case before me that said they reached out or tried to reach these jurors, we would have an indication there may have been reasonable diligence. There's no evidence of that at all. There was no attempt made, even though the media is talking to these jurors, although they're available immediately after this case. I think that's significant for why there's no reasonable diligence and why the trial court's finding of that can be disturbed on appeal under abuse of discretion standard.
I guess to me, I'm still searching for that date when the attorneys who are supposed to be doing post-conviction relief are appointed, because clearly they would be the attorneys who are working on the things that happen outside the record. Do you happen to know that date?
I don't know the date off the top of my head. I can just tell you that there is no constitutional right to post-conviction counsel. It's something that the defendant has to go ahead, they have to advocate for their rights on their own in that regard.
But with death penalty cases, that's an exception, right? Don't they have those attorneys appointed?
I honestly, I can't, there is a statutory right, that's correct. So I really don't know that date.
Because how do we say what's due diligence and not? If they're appointed after a deadline, then obviously they don't have time to have due diligence.
In these circumstances, Judge, I think that we can look at a 16-year delay, and then all of a sudden we've come up with this issue. That's something where we are undermining the finality of this judgment.
But would you agree with opposing counsel that it's not that 16 years, but instead the 120 days?
I think in order to assess reasonable diligence, you can look at the fact that it's been 16 years. Because that, so if this court were to come out and say that, yes, this is something that could have, there's no reasonable diligence requirement in this, that would encourage defendants to sit on their rights for decades and then come forward with a claim like this and ask for a new trial.
Why would they do that?
Pardon?
So-
Bill, because hopefully maybe witnesses would be gone, there's going to be new changes in law that maybe weren't applicable at the time, maybe there's a new jury pool. It's a second bite when that isn't allowed under the law. And if you sit, that could be within their strategic benefit.
However, the 120 days, it still has to be reasonable diligence, so they can't just sit on their rights, because if there was, for instance, if it was, let's say the newspaper did publish an article that this particular juror, or any juror, said, I was strong-armed into voting for the death penalty. Then if they didn't interview that juror, then that would be a lack of due diligence. But if there's no indication of that, why should that be a lack of due diligence?
Well, it's not a case where we should allow new sets of lawyers to look at a case and think, oh, this might be an issue, now let's try this. Let's try this now, let's try this. We're trying to avoid that with our law because that undermines what the finality of one of the cases.
Well, this is an aside, I was going to ask the appellant about it, but even if that juror's comment or statement or whatever, I'm not even sure, would that be admissible? In other words, can she impeach her own judgment?
You mean in the post-conviction standing?
So what? So she says, this is not the way I understood it. Can she impeach her judgment and the judgment of the whole jury on the basis of a statement made 16 years later?
I would probably argue not about when it comes to the merits of the case, but at this point, I really not consider that because that's not our posture.
So you're saying that in determining due diligence, we don't look at all whether the allegation that is made has any even merit on its face?
I don't think you I believe you should
So
look
you
at.
could say the janitor came in
I mean, literally, so
and
Judge,
therefore we get at least file a motion for new trial?
that's, I mean, this affidavit very well could say, I looked up, the sky was green, so I decided to convict that day. That, it's not about the merits of what that claim is at this point, it's about leave. And whether there's reasonable diligence in finding the evidence to go forward with that.
Right.
And I just see no evidence about this. And I mean, there's well-regarded, well-settled case law about incarceration is not itself a reason for why you didn't exercise reasonable diligence. It is something that you have to exercise and you have to go forward to it. And you know, if it's something where this was discovered, I mean, if post-conviction counsel was appointed, you know, if you look at that from 120 days from now, what was discovered then? So it's not something where, hey, we go to federal court, there's a whole process of discovery, we find a brand new thing that wasn't discovered previously, so now I can raise it. I think that's a very bad standard for this court to adopt. I don't think it's what the law requires.
Do you agree with Judge Lanziger intimated to this, but I want to make sure I get a clear understanding of what the state's position is. Do you agree with the appellant that Bethel says you only look at the 120 days for the exercise of due diligence?
I do not believe that is what the law requires. I think you have to consider all these circumstances when gauging whether there's reasonable diligence. And because of the very specific claim involved in Bethel, I just don't think it relates here. And I think it's also important to note Bethel was a 4-3 decision. It is very hotly contested at the court's level above us. So based on that, I really think that Bethel's not something this court should be considering.
Well, we have, whether it's 4 or 3 or not.
Oh,
we have
yeah, of course,
we have
yes.
to abide by it.
We absolutely are abiding by that. I'm just pointing out that there is a very hot take above us about it. So I think Bethel's immaterial here. There's just no evidence of reasonable diligence. I think the trial court was absolutely within its discretion to deny leave in this case. Especially in a case where originally it was filed before leave was requested, without even requesting leave. So there's a double filing in this case as well. So based on those factors, unless there's further questions, I just ask you for the trial court.
Thank you.
Thank you.
Judge Lanzinger, I can start by addressing your question about post-conviction counsel. Post-conviction counsel was not appointed. The notice of appearance was filed May 15th of 2007. I'd like to start by reiterating Bethel is good law, and Bethel did articulate that the reasonable time filing requirement, which was a judicially created rule, does not exist and was not within the Criminal Rule 33. We're not saying that reasonable diligence should be thrown out. The facts of this case establish that counsel could not obtain or discover this evidence within 120 days utilizing reasonable diligence. Reasonably diligent counsel would only begin jury investigation, jury interviews after having the opportunity to review the entire transcript and the record. Because this record was not filed until after 120 days, reasonably diligent counsel was precluded from engaging in those jury interviews. The very fact that this juror's name, again, does not immediately lead to the conclusion that counsel had the operative facts to begin comprehensive jury interviews. And again, interviewing jurors multiple times poses a danger not only to the juror's peace of mind, but also to the defendant's underlying claims, especially claims of innocence where a badgered witness is not seen as reliable as one that hasn't been spoken to over and over again. I would also
Counsel, let me ask you the same question I asked the state in regard to, I understand we're not looking at the merits per se, but let's just say the affidavit for the request for a leave to file a new trial says something that is absolutely not ever going to be the basis of a new trial, says, that the defendant, just thinks that he was, not treated properly, which obviously would have been in a direct appeal and so forth, because it rained that day. Okay, and you couldn't discover it for whatever reason. I mean, how do you completely divorce yourself from the actual merits of the case, is what I guess I'm trying to say.
Your Honor, I would agree with my friend on the other side that this is a bifurcated process. It triggers a bifurcated judicial inquiry. And the first question before we get to the merits of the underlying new trial motion is whether the petitioner is unavoidably prevented. So while it may seem like an absurdity, yes, we do have to separate those two facts. And during the initial inquiry, the only question before the court is whether the petitioner has provided clear and convincing evidence of unavoidable prevention. Where a prima facie case is established through the motion, but there are discrepancies, a hearing is the best place to resolve those discrepancies.
But again, even that hearing would only go to whether or not there was due diligence exercise.
That is correct, Your Honor.
So you're saying you can, in an affidavit, I have to think of hypotheticals, in an affidavit you could, like you said, have some absurdity that would never grant the defendant relief ultimately for a new trial, but the court would still have to hold a hearing and entertain a motion for a new trial.
Your Honor, I would just answer that the hearing should only be held where there are the discrepancies to resolve. If the appellant has not provided clear and convincing, or I'm sorry, a prima facie case through the motion, then at that point the court can deny the motion for leave without a hearing. But where there is prima facie evidence establishing unavoidable delay, then yes, a hearing.
And that's, I'm sorry for interrupting you, I know you're running out of time. So what you're differentiating again is the prima facie case, which is what I was getting at, would only go to whether due diligence was exercised and not what the reason for a new trial is.
That is correct, Your Honor.
Thank you.
I see that I'm running out of time.
Yeah, I apologize, but it's fine because I was asking you questions to let you go before, so.
Thank you.
All
I would
right.
just respectfully request this court reverse the decision of the trial court and remand this case. Thank you.
Thank you. The court will take the matter under advisement and will issue a written opinion that will be sent to both sides as well as being released on the Ohio Supreme Court website.